All right. Hello and welcome everyone to today's webinar, Climate Justice, How Enforcement Can Help Communities at Risk. I'm Matt Schutz, I'm Executive Director at the Center for Progressive Reform. The Center for Progressive Reform is a think and do tank with a network of more than 60 member scholars working to build thriving communities and a resilient planet. We drive policy reform with rigorous and accessible legal analysis designed for change makers. Today's webinar is the second in our Climate Justice webinar series. Last month, we focused on climate-induced displacement, migration, and relocation. And I hope you'll join us next month for a discussion about climate torts, what we might take away from the recent Juliana decision, and more. You'll see an invitation to that webinar in your inbox in the next couple of weeks. I'll start with brief introductions of our speakers, and then we'll get going. Joel Mintz is Emeritus Professor and the C. William Trout Senior Fellow in Public Interest Law at Nova Southeastern College of Law. He's also a longtime member scholar at the Center for Progressive Reform, and as of last year, a member of our board of directors. Joel has researched and written extensively over the years on federal environmental enforcement policy. Cynthia Rice is the Director of Litigation, Training, and Advocacy at California Rural Legal Assistance. CRLA is a nationally recognized leader in farm worker and migrant service provision, employing community outreach, educational training, and direct legal services. Cynthia specializes in labor and employment rights and has represented thousands of workers in administrative and court proceedings over the years. Jon Mueller is the Vice President for Litigation at the Chesapeake Bay Foundation. CBF is the largest independent conservation organization dedicated solely to saving the Bay, and Jon leads a multifaceted litigation team. So great group of speakers with us today, a variety of perspectives on the impacts of the climate crisis and how public interest advocates can leverage legal and regulatory enforcement tools to help the communities on the front lines of the crisis. I want to kick things off with a question for each of our guests, which is, can you tell us about the impacts that you're seeing in your work from the climate crisis? Cynthia, I'll start with you. What are you seeing and hearing when you meet with farm workers in California?
So because I'm a farm worker advocate, I look at climate change through the view often of the workers that I represent. And what we see are the impacts of increased temperatures, impacts on the water table, as well as the level of heat in the fields, not only impacts on the workers themselves as they're in the fields, but also on the crops they produce and the change in business practices that they encounter as a result of that. If you want to flip through to the next slide, or do you want to, yeah. And so what we really look at this is climate change on the effect on workers. So rising temperatures affected business practice and working conditions, and there are multiple studies, reports, documentaries about the impact that rising temperatures has had on agriculture production in the country, and in particular in California. We have reports of crops dying in the fields and increased reliance on irrigation water, its effects on the water table effects on surrounding farm worker communities by reducing the availability of well water. And the reaction to this has been twofold. One, to change the types of crops that are being grown in California and around the nation, but also to change the approaches to how crops are harvested and produced. And if you go to the next slide. Next slide. And one of the impacts of the increase in heat had been, over the last decade, a fairly dramatic increase in fatalities related to heat stress. This is a map from 2014, and in various parts of the country, these numbers have actually increased. In California, as a result of some activism I'll talk about, they have they have actually fallen off and decreased as a result of regulatory change and enforcement. But heat stress has become a major issue within the workplace that needs to be addressed from the perspective of business practices and crop management. Next slide. Next slide. There was a federal OSHA, federal and state OSHA response to that. The working conditions are generally regulated by both federal and state law. Federal sets a floor for working conditions protections, and if you go, and states can augment those protections. Federal OSHA has, again, in the last 6 years, made an effort to encourage employers around the country to address the effects of rising temperature change on their workers by implementing really largely voluntary steps to mitigate the effects of heat by increasing, making water available, making shade available, and increasing the number of breaks. California saw that the reaction to these voluntary suggestions was not adequate to eliminate deaths or decrease incidences of heat stress, and actually enacted specific regulatory requirements that impose requirements on employers to provide water in a more accessible form and established amounts, shade, as well as increased rest periods when the temperatures in the field reach a certain level. So response was critical to, in advocates' view, to creating a real enforceable standard for the purpose of making sure that the effects of increased heat on the workplace would be addressed in a manner that increases protection. Next slide. And but in addition to that, there has been a whole change in the industry itself as a result of the increase in heat that we're seeing in California fields. And this is true across the state as well. And that has been by an increase in the use of night work. And that is workers who no longer report to work at 4 or 5 in the morning, but now report to work at 6 or 7 in the evening after the sun has gone down. You'll see a variety in the links that you have here. You'll see a variety of justifications for this work, particularly in the grape industry, which is demonstrated here, that it actually improves crop quality and taste and flavor. But the truth of it is that much of these practices increased and went into effect after the establishment of the heat stress regulation in California. In other words, the reaction was not to provide shade, not to comply with these extra rest periods, but in fact to change the hours of the work so that workers were not subjected to high heat. The trade-off, of course, from the perspective of the workers is that they were actually working in a more dangerous environment because of the exposure to risk like tripping, falling, inappropriate use of tools, and even exposure to snakes and other vermin increases significantly when workers work at night. So again, with the change in with the high heat, there was a change in production practices. The change in production practices mitigated the impact on crop, but actually had the impact of increasing the incidence of night work and related injuries. Again, next slide. Again, there was an effort to either reduce or address these high hazards that could not be affected voluntarily. So California enacted a regulation, which is pending final enactment, that would specifically require lighting standards, not only in the field as you saw there, but at the restrooms, in the ingress and egress points, and establish a candle rating that was a minimum standard that could be applied. Again, without these regulatory mandates, we were finding that we're not able to enforce any of the general safety clause protections that are generally applied in worker safety. And then next slide. The other major impact that we have seen in agriculture as a result of the significant increase in heat that we've experienced in California is the wildfires. And as any of you who have followed the national news in the last 3 years, you know that California is now in its 3rd year of devastating wildfires that have impacted not only rural communities, but obviously rural agricultural areas. The impact of this has been, again, there's been widespread reports of crop loss, but also there has been a real tension between employers and their workers in the agriculture industry about whether or not those workers could go home. And as you can see from this slide here, workers weren't allowed to go home. They were required to continue to work. This is a picture of the first fires down in Oxnard. And with that cloud of smoke coming toward them, even though the fire does not put them at risk, obviously the increase in particulate in the air and the reduction in air quality puts them at a great risk. Next slide. And next slide. The growers' response immediately was not necessarily to either pull the workers out of the fields or to address these health standards, but instead suggest to the workers that they take their own steps to provide protection. As you'll see here, a worker tying a kerchief around her face for the purposes of providing at least a limited reduced exposure. In fact, those type of measures are not mitigating in any significant respect. And again, what we saw right after the fires is an increase in respiratory illnesses in the areas that that the fires occurred that was higher for workers, and there was a long-term impact on respiratory disease and heart disease. Next slide. Again, as a reaction, there was a recommendation that under the employer's general safety clause requirements and individual safety plans that they take mitigating measures. That didn't happen. And so emergency legislation and then emergency regulations were adopted in California. Significantly, neither the industry nor the regulators could agree that at a certain point in time, work should be prohibited. So there actually is no express standard that requires employers under circumstances where workers are exposed to particulate, even high levels of particulate as opposed to fire, to pull the workers out. Next slide. So, yeah, sorry, you can go back to the last slide. So essentially what we saw is an increase in a dramatic impact on agricultural production and crop management. The resulting impact on exposure to workers, the adjustment of that impact on the crops by employers, by growers, which in fact exacerbated the impact on workers, and then the need to come in and implement statutory and regulatory change to address the need for additional worker protections. California is at the forefront of this activity, and if you look around the country, particularly in the Southwest and parts of the South, the impact on the increased heat in agricultural fields and other areas is as real as it is in California, but many states are far, far behind California in terms of developing additional worker protections. And as I previously indicated, the federal OSHA has not yet stepped up to address any of these risks in a mandatory regulation.
Yeah, thank you, Cynthia. So that given that California is a leader, I want to circle back to you in a minute. so that we can talk more about some of the litigation enforcement activities that other groups might learn from you about how to push these policies forward in their own states. But before we do that, I want to give Jon a chance to jump in and talk about some of what he's seeing from his perspective, working to protect the Chesapeake Bay as a resource, and what he's seeing, what climate impacts he's seeing in the communities he works with.
Thank you, Matt. Appreciate it. Maybe you could go to my first slide there. So Chesapeake Bay Foundation headquarters are in Annapolis, Maryland, and we work throughout the Chesapeake Bay watershed. And the Bay proper, covers primarily Maryland, DC, and Virginia, and some Delaware waters. And so we've been looking at this question of climate change, sea level rise, what are the impacts to the Bay, and what are the impacts on minority communities. We just recently started an environmental justice program and hired an attorney to work with us on that, Taylor Lilly. And so we started to explore a couple of these different issues. And of course, temperature is a big problem because as as water temperature rises, the ability of it to hold oxygen decreases, and that is bad for those organisms that live in the Bay. But we also want to focus on what are the impacts to people. And while that's certainly going to have a problem, the temperature rise for people whose livelihoods, like watermen, depend upon fishing and oystering, crabbing in the Chesapeake Bay, we think there's also a much bigger problem that's associated with sea level rise. So this picture right here is Annapolis City Dock. They just spent a couple $1 million to upgrade the dock to stop sea level rise. And as you can see, it's not really doing much. This is what we call sunny day sea level rise, and not associated with storm surge or anything like that. And it shuts down a number of streets in and around the Naval Academy in downtown Annapolis. And this is occurring throughout the Bay. So if you go to the next slide, please. So with respect to sea level rise, it's extremely large shoreline. We also have the problem of land subsidence that is just a geologic issue in which when the bay was formed, it was formed by a meteor striking down at the southern part of the bay, what is now the bay. And so the land is still sinking, plus water withdrawal for drinking water and industry is also causing the ground to compact. And we've got major population centers, Baltimore, DC, Norfolk, Hampton roads, big issues for us. Next slide. And by the way, that last slide, the house in the background was on Holland Island. Sorry, Matt. And that house did go under the waves. Holland Island is no longer there. And unfortunately for the Bay Foundation, we have had to close one of our island education centers known as Fox Island down in the lower part of the Chesapeake Bay because it's not safe to take students there anymore as part of our education program. So we are seeing this firsthand as an organization. Next slide. Thanks. So we've been keeping an eye on the trade press, scientific journals, and trying to get an understanding of how big a problem this is in the Chesapeake Bay region. We've been keeping an eye also and paying a close attention to the National Oceanic and Atmospheric Administration's sea level rise mapping tool. I don't know if you all have looked at it, but it is a pretty dramatic visualization of what is projected to happen over the next 20, 50 years. And it's not a good picture if you're living in a coastal area, both from sea level rise, but also storm surge. And so a recent paper came out by Professor Hummel. It was published in a number of different journals. The link is provided there. And she and her team looked at the sea level rise mapping tool and try to understand what the impacts might be for wastewater treatment plants. So for us in the Bay, trying to reduce the amount of nitrogen, phosphorus pollution that's coming from wastewater treatment plants has been a big issue. And we feel like we're finally starting to get a handle on it. A lot of the wastewater treatment plants are upgrading or have upgraded already to meet pretty rigorous treatment standards. But now there's concern about whether they may actually be able to continue to function if sea level rises, because as you might expect, a lot of these wastewater treatment plants, because they discharge to water, are not far from bodies of water. So here in the graphic on the right, Professor Hummel took a look at wastewater treatment plants in the San Francisco Bay region and tried to determine which ones would be affected with a different amount of sea level rise. And you can see those in red that it's going to be pretty impactful for them. We then went on and took a look at, well, what is the community being served? How many people are going to be impacted if that wastewater treatment plant won't work? And came up with some, I believe she used census numbers to determine how many people were going to be harmed, and some of the numbers are pretty striking. And so I contacted her and asked, do you have anything like this for the Chesapeake Bay region? And she was kind enough to actually plot out all of the different wastewater treatment plants in the Chesapeake Bay region, and then provide information on the number of people that would be impacted depending on a 1 foot, 3 foot, 6 foot sea level rise. If we can go to the next slide, please. So you can see in the gray triangles here are all the wastewater treatment plants surrounding the Chesapeake Bay that are subject to tidally influenced waters. And we know with 1 foot sea level rise, based on the NOAA projection, that 4 plants in red are going to be affected, and that is about over 500,000 people. So that's just in the next year. So we decided to look at, all right, what's going to happen to some of those plants. Next slide, please, Matt. And then by 2060, there are now 12 facilities at risk, and over almost 1 million people will be impacted with population growth in this region increasing every day. We can expect that it's going to be easily in excess of 1 million people. Next slide. So we decided to try to focus on one plant and the Norfolk Hampton Roads region. And this is an image of the Hampton Roads Lambert's Point wastewater treatment plant. It's run by the Hampton Roads Sanitation District. And it was just upgraded at a cost of over $124 million to meet some of the new wastewater treatment plant permit limits that were necessary to return the bay back to get it off the impaired waters list. Next slide. Just to give you an idea of where we are, so the 4201 Powton Avenue is where Lambert's Point is located. You'll see to the north is the Virginia Port Authority, the Norfolk Terminal, and then the Norfolk Naval Station, which is one of the largest naval stations in the world, and they are quite concerned. The Navy is quite concerned about sea level rise and has been doing a lot of projections about what to do, because as you can see from this map, a lot of the major roads that get in and out of places are taking you to a peninsula. And if those roads are inundated, you can't get in and out of those areas. Next slide, please. So back to Lambert's Point, by 2060, if we expect a 3 foot sea level rise, and this is just at the intermediate level, not at the what NOAA calls the extreme level. You can see the blue areas there just above the large gray part of the picture is actually the Norfolk coal terminal. So their trains are bringing in coal, dropping it off, and it's being picked up by shipping and removed, taken overseas. And so just to the north of that you'll see the Lambert's Point Golf Club, and between the coal plant and the golf club is the wastewater treatment facility. And the light blue areas are areas of where inundation is expected to occur. So we can expect that by this point that the plant is not likely to function according to Dr. Hummel's projections, because parts of that plant will be inundated and will not be able to work. Next slide. And so now we're just looking at typical sea level rise. This is again sunny day flooding. And you can see large portions of the Hampton Roads and Norfolk area are going to be inundated and are already being inundated at a regular occurrence. Next page, excuse me, next slide. Back again, this is just sunny day flooding for Lambert's Point, and the red areas indicate where we're going to have sunny day flooding that will also inundate part of that plant and perhaps not allow it to function. One of the things that's particularly disturbing about this image is you'll see Old Dominion University in the top center, and below that are a number of row homes and a large red patch right there in the middle that is going to be inundated just by high tide flooding. Next slide. So who lives there? This is the census data on the demographics for the area just to the east of Lambert's Point. And these are the area and the population that's going to be affected by the failure of the wastewater treatment plant and the sunny day flooding. And you can see large portions of red are actually 95 to 100% minority communities, low economic communities, people living just in poverty. And the problem, again, that they face is where do they go if they're no longer able to use the sewage system? Where do they go if their roads are flooded and they can't get in and out? So we have been looking at a number of different ways that we might be able to handle this. I think a lot of us kind of had our hopes set on the Juliana case, and I know, Matt, you all are going to cover this in your next webinar. With the seeming failure of that case to be able to go forward, are there other avenues for us to be able to do something about this problem? The Army Corps is already projecting doing a number of projects to try and stop some of this. Just below the coal plant on the left, they're actually talking about building a gigantic seawall and create berms all the way around the Norfolk, Virginia Beach area at a cost of several $billions, a lot of hard infrastructure. Good question about where that money is going to come from, who's going to pay for all of this. So we do believe that it's time for the federal government to act, and we're actually looking at a number of ways in which we might be able to force the government to act, at least in the Bay region. We think there's a particular provision within the Clean Water Act that will allow us to do that, and we'll continue to conduct research to try to exploit that. Thank you.
All right, thank you, John. Joel, I want to draw you in. Cynthia and John sort of grounded this discussion in the fact that climate crisis is having significant impacts on vulnerable communities, the farm workers in California, the people who depend on these water systems around the Chesapeake Bay, wastewater treatment systems. I wonder if you could talk a little bit about enforcement policy and agency resources. You just published earlier this week a great piece in the Revelator, tells sort of a terrifying story, honestly, of cops walking off the beat. I wonder if you want to address some of the issues you raised there, or anything else.
Okay, sure, Matt. Actually, the most recent numbers regarding the achievements and activity levels of EPA's enforcement work are found in a very recently issued EPA report that's entitled Enforcement Annual Results from Fiscal Year 2019, very prosaically titled. And that report reveals a sharp drop-off in the scope and the volume of EPA's collective enforcement efforts in the early years of the Trump administration, particularly when that's compared with EPA enforcement in the early years of the Obama administration, and that seems a fair basis for comparison. To me, the most telling metrics concern the number of in-person facility inspections by EPA personnel, the aggregate amount of money that polluters were forced to invest in pollution controls as a direct result of EPA enforcement actions, and the numbers of criminal enforcement investigations that EPA opened up. Last year, EPA employees inspected 10,320 facilities, and that's a far cry from the 21,278 facilities the agency inspectors visited in 2010. EPA enforcement directly resulted in almost $4.5 billion of pollution control expenditures last year, as compared with the $21.3 billion of private pollution control investment compelled by EPA enforcement in 2011. And EPA opened 170 criminal enforcement investigations in 2019, yet it began nearly 400 such investigations in 2009. I think there are several policy-related reasons for those dramatic changes. First of all, EPA has ended its decades-long oversight of enforcement by state environmental agencies. It's also adopted a policy of relying on the states to do a great deal of the enforcement that the federal agency used to do itself. And that's been a problem for two reasons. First of all, in many cases, states lack the resources to do a credible job with regard to environmental enforcement. For the 10 years preceding 2018, state environmental agencies lost an aggregate total of 4,400 state agency employees, and many of those worked in state environmental enforcement programs, which were hard hit by state budget cuts. Secondly, while some states like California, New York, and Massachusetts are exceptions, many states simply lack the political will to vigorously enforce environmental requirements. Since 2017, in addition, EPA's political appointees have actively discouraged direct enforcement work by federal agency personnel. That's been especially true in EPA's regional offices. A lot of the enforcement actually takes place in the regions when EPA is doing it, and Trump administration appointed regional administrators have often evinced hostility toward federal enforcement work. There hasn't been too much press attention focused on that, much more on headquarters, but I think a lot of the damage is done in the regions where the actual work takes place for the most part. Moreover, EPA's own resources for enforcement have dropped down in parallel to the decline in state agency enforcement resources, as well as an overall decrease in EPA personnel. From a high point of over 18,000 EPA employees in the Clinton administration, fewer than 14,000 people now work at EPA, and the personnel levels within the agency's enforcement program, both in headquarters and the regions, experienced a proportional decline, actually beginning during Barack Obama's second term. Finally, there appears to be widespread demoralization among EPA's professionals who are tasked with enforcing pollution control standards, and that may well have affected the efficiency and productivity of enforcement. That's what tends to happen with low morale in large organizations. EPA's most recent self-reporting does demonstrate that, contrary to what some people seem to believe, EPA has not completely stopped enforcing environmental laws. In fairness, I think the agency has done an especially effective job of enforcing requirements pertaining to lead paint in public housing projects, which is a significant public health problem. However, overall, it's clear that with regard to enforcement work, EPA is doing far less than it could, or in my opinion, should do to hold environmental polluters to account.
Okay.
So we started.
Yeah. No, I'm reacting to sort of the doom and gloom with which we started this webinar. It's a lot of bad stories, right? I'm hoping maybe we can find some rays of hope here in the work that you all are doing. So maybe, Cynthia, this is a good time to loop back to you and hear about an example, maybe a case or two that you've been a part of that sought better protections for workers from heat stress or some of the other climate-related hazards that you were discussing before?
Yeah, much of our direct advocacy surrounding heat stress and night work and wildfire protections is the promotion of regulatory response to these issues as they come up. And as I indicated earlier, the federal government, and just to kind of follow up on what Joel said about federal enforcement and the critical problem that has come up with a decrease of enforcement, is that the floor for these standards is set by the Federal Occupational Safety and Health Act. And I believe it's still a majority of the states rely completely on federal regulation for the purposes of establishing the minimal safety and protection standards at the workplace. So if the feds don't move forward and respond in a regulatory manner to these increased risks that are driven by climate change, then for most states in the country, there will not be an enforcement mechanism. And so California and the other what are called state contract states who contract with federal OSHA for funding to do worker health and safety enforcement, but have the latitude to develop their own regulations and laws, have had to come up and identify the problems, respond to them with regulation, and then with an enforcement strategy. And CRLA has for really decades invested in a cadre of community workers that are based in our local offices that actually go out and do field monitoring on high heat days. Our community workers go out with temperature gauges, and in the event that they encounter a field where shade is not available or the increased water provision does not appear to be apparent, we've negotiated with the Occupational Safety and Health Administration Enforcement Agency in California that we can do a declaration, do an immediate complaint, and have an immediate response in high heat situations by the agency to come down, issue a citation, require ameliorative actions, or even shut down the operation. So that was one advocacy effort that has been tremendously helpful for us, and in our view has actually expanded the enforcement capability of our state occupational safety and health agency significantly. And we believe has increased enforcement, or I should say compliance with those critical protective measures. Another, and we are just starting a similar campaign around the wildfire standard, which requires the provision of higher level respirator masks and additional heat measures, as well as the night work safety standards. So that's one way that our advocacy efforts have increased protections for California workers. Another way is that we have a statute that's somewhat unique in California. Our unfair competition law actually allows us to go in and obtain injunctive relief when a business or an operation is engaged in an unfair or unlawful business practice. And we have in the past used this successfully to obtain temporary restraining orders and preliminary injunctions to address the failure to comply with various regulations, and notably the heat stress regulations and provision of shade and additional water. So those have been two strategies that we have used to address direct enforcement at the workplace. Additionally, we have looked at a number of approaches where we feel like our our state regulatory agencies, whether they're locally based like our agricultural commissioners or our agencies, either OSHA or pesticide, Department of Pesticide Reform, have not really moved as far as they should have in either developing an enforcement approach or developing and promulgating regulations that affect statutory standards. And through writs of mandate, have been able to identify areas of regulation. Heat stress was originally one of them, where the agency, by operation of a superior court order, was ordered to go back and engage in rulemaking in a manner that met the statutory requirement. So those are the types of advocacy approaches that we have been using, both administrative and legislative advocacy, as well as court advocacy, really pushing the enforcement and construction of these laws. And again, as everybody knows, legislation and regulation as well is often sausage making and creates standards and mandates that are subject to construction. And so we have used declaratory relief, both at the federal and the state level, as a manner of creating a bright line for enforcement that is available to us as advocates when working directly with growers, but also, and importantly, is a mandate that we can then impose upon the regulatory agencies themselves and say, okay, this is the standard that needs to be applied. Nationally, with respect to heat stress, a number of organizations and unions in particular have at the federal level with federal OSHA been using the general safety clause to take the position that the federal agency should be citing in circumstances where workers are subjected to continued work in high heat situations. And there has been persuasive and advocacy resulting in citation by the agency in some jurisdictions during the Obama administration. As a result of those citations, there are a number of appeals out there now pending before the Federal OSHA Appeals Board, really construing the breadth of the general safety clause and with worker advocates taking the position that the agency should have broad authority to identify health and safety standards or conditions, many of which are driven by climate change, that create a safety risk and cite on them even in the absence of a very specific regulation. Those cases are working their way through the Administrative Appellate Division of the OSHA Appeals Board, Federal OSHA Appeals Board. And some of them we believe we're going to be successful in establishing those kind of bright lines. Others we expect to go by the wayside, and then we'll be in the same position as Joel was describing with respect to the EPA, really at the mercy of the discretion of the federal enforcement agency to ensure that these protections are afforded to workers.
Yeah. The general duty clause seems like something that's really, in a lot of different contexts, never really lived up to its potential, unfortunately. But hopefully, as this litigation progresses, we might see something positive in this realm. Jon, you sort of hinted at one of the litigation strategies that you're exploring right now. I wonder if there are any particular cases in recent years that you've worked on that you want to highlight for us.
Yes, thanks, Matt. There are a number of things that we have been doing that are tangentially related to this question of climate change and impacts on minority communities. So, one of the things we've all seen is this tremendous rollback on the Trump administration and the Wheeler and Pruitt EPAs to gut a lot of the Clean Air Act protections that were put in place, and actually I enforced when I was at the Justice Department. So we have been spending a lot of time trying to defend those rules and try to overturn the new rules that the Trump administration has been trying to get through. And so we've got a number of cases now. There are some 126 petitions under the Clean Air Act and for Maryland and Delaware to try and protect human health. And so we see a connection between NOx, nitrogen oxides that are emitted by automobiles and coal-fired power and other fossil fuels, and particulate matter and human health impacts associated with that. And we know that if we're able to get those regulations to remain in place, that we're going to see a likewise reduction in the amount of carbon dioxide and other greenhouse gas emissions. So we see, several kind of touching points that are critical to our mission. One, of course, protecting the resource, but also protecting human health. We've also been engaged in a years-long fight against the Atlantic Coast Pipeline that Dominion Resources, Duke Energy, and Southern Company are trying to build from West Virginia down through Virginia and into North Carolina and South Carolina. And we've been fighting this on a couple of fronts because we recognize that there are going to be some pretty significant impacts to water quality due to runoff because the pipeline is going to go through a very mountainous region. But we also have the associated air impacts, climate change impacts that are going to be associated with the combustion of all this new fossil fuel, that natural gas that the pipeline is going to transmit. One of the big things, one of the big cases we've had on that matter is trying to stop a gas compressor station that's slated to be constructed in Buckingham County, Virginia, within a mile of historic African-American community. These were descendants of freed slaves who had bought their land from former slaveholders. Ironically, the plant is going to be constructed on property that was sold by the heirs of the slaveholders. We've got a very good decision out of the Fourth Circuit Court of Appeals that said that the Virginia Department of Environmental Quality and the Air Board did not do a sufficient job in paying attention to environmental justice factors and issues unique to state law concerning site suitability. So now they have to go back to square one and see if they can actually get an air permit for this plant that will be protective of the people that live nearby, but also reflect the problems that we expect to occur as a result of all this fossil fuel combustion. In addition to the litigation, CBF is pretty heavily engaged in advocacy and trying to, both at the state and federal level, to improve laws and regulations that are important for addressing climate change. So there's going to be increased rainfall, there's going to be more runoff, and associated runoff will bring more sediment pollution into local streams and rivers and the bay. That's another one of the primary pollutants that we're trying to curb in the Chesapeake Bay under the Bay Total Maximum Daily Load. And we don't believe that state or federal regulations are adequately protecting for that. They're not protective enough. So we're going to be working pretty hard. And Nat, working with the Chesapeake Accountability Project to try to affect change, at least in Maryland, on the way their regulations. The other thing that we're doing a lot of is restoration. So we have a pretty significant 5-year campaign going on. And two parts of that campaign are to restore trees, and 1 million trees and 1 billion oysters in the bay. We're not going to do it all by ourselves. We're going to certainly have a lot of help from that. But if we're able to plant more trees along streams and rivers to get protective buffers, will slow down the runoff and the nitrogen, phosphorus, and sediment pollution associated with that. But we're also going to be doing a fair amount, or the trees will be doing a fair amount of carbon and greenhouse gas capture. So that's a pretty significant project for us.
Yeah. Thank you, Joel. I know you don't litigate. CPR doesn't litigate, but I wonder. I know you're working on a campaign around the White House sort of interference in regulatory enforcement. There's a notice out of OMB recently, and I know you've been looking at that. Given that both Jon and Cynthia have mentioned the importance of the federal government in setting setting sort of baselines or floors for what can be done. Any thoughts, anything you want to share about what you're reading in that RFI and what that might mean for how agencies are able to enforce their existing laws and any implications for climate change?
Sure. Well, I think there are a number of changes that would and could improve federal enforcement by EPA. First of all, in my personal opinion, not that of CPR, which is a 501c3 organization, but in my own view, I think replacing Donald Trump as President of the United States would be a great place to start. But at a lower altitude, increasing the number of EPA employees generally and EPA inspectors, enforcement attorneys, enforcement engineers, and criminal investigators in particular would be a major step forward. EPA is already extremely short-handed regarding its enforcement work. And if the agency has demanding new enforcement responsibilities under future federal climate crisis legislation, it'll certainly need more enforcement personnel or enforcement in other areas, air, water, hazardous chemicals, et cetera, will suffer greatly. Thirdly, EPA certainly needs to assert its oversight of state agency enforcement and step up its own independent enforcement work free of undue deference to state preferences. That's just sort of restoring the status quo ante, but it's something that will help a lot. And finally, with respect to the regulation of greenhouse gases from some industrial sources, not all sources, but some industrial sources, EPA may want to duplicate some of what was done in the acid rain control program by employing continuous emissions monitoring systems and automatic self-reporting to a central data point. That worked quite well with controlling SO2 for acid rain, and I think that no matter whether it's a taxation system or a cap and trade system, it has potential to work quite well with regard to greenhouse gas emissions. So those would be my recommendations.
Yeah, thank you. Thank you. So I just want to remind our viewers that they can feel free to type in questions into the Q&A feature at the bottom of their screen. We've got a couple that we've answered just directly, but I do have another one that I want to raise with our speakers, and this sort of dives in deep on enforcement policy and practice. And so I don't know, Jon or Cynthia, if you want to take this first, either one of you. The question is about settlement agreements and how they can be sort of manipulated by industry to weaken worker protections, pollution standards over long periods before compliance deadlines. And so the question's, what are some climate relevant vulnerabilities or risks that advocates and regulators should consider in settlement negotiations to ensure that long-term requirements to remediate violations are responsive to changed climate conditions, and that shorter term mitigation measures are adequately protective of workers and the public? I don't know if either of you have thought, obviously very different regimes governing public interest groups' involvement in settlement negotiations on the environmental side versus the labor side. So I don't know if either one of you want to take that first.
Well, let me just, and again, I'm not sure this is totally responsive, but certainly a challenge that we have had is in some of our environmental justice work is the impact that it has on the working community when the ultimate remedy that we're seeking is either elimination or scaling back of a particular plant that may have an impact on jobs in the area, right? And so we often face the same kind of criticism in our regulatory work with increasing health and safety protections that, look, you know, every dollar or $10 that we spend on additional shade protection or masks or whatever protective measures is a dollar that we can't pay to workers or a worker that we can't employ altogether. And although I don't think it's necessarily an issue we address directly in settlement, what we do both in our regulatory and advocacy and in shaping our settlement agreements is try to build in stopgap measures to make sure that the ultimate actions that are required won't have an impact that results in a reduction of the workforce or provide an excuse, if you will, for displacing workers for a short period of time and then pulling up in a different workforce. So although it's, and on a more relevant note, we have a community equity initiative that has been doing a fair amount of work looking at unincorporated communities and water resources that are available to them, which have been diminishing exponentially as the water table in California shrinks, because so many of these communities are dependent on shallow wells. And we're finding, in fact, that legislation and regulation and enforcement approaches that we looked at with the forming of small water agencies, even as recently as 15 years ago, are completely antiquated now because there are so many factors, more factors that need to be taken into consideration about access and usage based on the impact of climate. So I think all of us as advocates are now in this position that we have to read the crystal ball anytime we do some type of advocacy that's going to have to do with resource management, both with respect to how it's going to impact workers, but also with respect to whether or not that resource management is even going to be relevant in 10 or 15 years, given the changes that Jon has described and that we're experienced with heat.
Yeah.
Yeah.
Yep.
Go
So
ahead. You still want to cover this, man, or are we good?
If you have something else you want to add, let's go for it. But otherwise, we have one other question that I want to try to get in before we close out.
Okay, I'll move quickly. I mean, one of the things that's been frustrating is it's, first of all, the change in the supplemental environmental project policy that the federal government has instituted, which is to say that municipalities, settlements with municipalities can't contain a SEP. And SEPs were, a very useful tool when I worked at the Justice Department trying to enforce environmental laws, because you're able to get some injunctive relief, basically, that provides for the resource and provides for citizens that use the resource. Now that very useful tool has been taken away from municipalities. So significant questions about what that's going to mean for municipal separate storm sewer permits, and if there are violations by municipalities, which we're seeing repeatedly, especially in Maryland and Pennsylvania, and that are not going to be addressed through a settlement that would allow for green infrastructure as opposed to paying a penalty into a treasury, whether that's state or federal. So that's a big problem. Two cases of note, one in Virginia called Phones Cliffs, for example, we've seen where a developer decided to cut down 13 acres of trees without proper permitting or erosion and sediment control runoff. The site is a unique site in the sense that there are a tremendous number of wintering and migrating bald eagles travel through this area. It's actually the bluff where Captain John Smith was purportedly shot at by Native Americans, and it is right adjacent to the Rappahannock River. So with the cutting down of all those trees, as you can guess, there's been a significant amount of runoff. We've just seen the settlement agreement that the state has put together, and it has no provision for restoration of those trees. So without adequate ability of citizens to participate, and fortunately I think we have an ability to comment, but as most people know, that once the government has engaged in a pretty lengthy settlement process with the defendant, the ability to get them to go back and change and fix something and require now the replanting of trees, for example, or somehow try to restore the resource is extremely hard to do. Then with respect to the Conowingo Dam, it's the last dam on the Susquehanna River. Susquehanna provides 50% or more of the fresh water into the Chesapeake Bay. We've seen in recent years significant storm events that have just completely overwhelmed the dam and scoured a bunch of sediment that has been trapped behind the dam. The dam is up for relicensing. It gets a 50-year license and is going through that process with FERC. Maryland gave a 401 certification attaching a number of conditions on that relicensing to protect water quality of Maryland waters. And part of that was to address the sediment buildup behind the dam and perhaps dredge some of it, perhaps pay some money for upstream restoration of vegetated buffers to try to prevent runoff. And now the agency, Maryland, is settling with Exelon, and none of that is in the settlement agreement. And again, citizens have a very limited ability to challenge this decision that is now before the Federal Energy Regulatory Commission.
Big case for Marylanders, for anybody who enjoys the Bay, and I think there's a lot going on in Annapolis around that right now. So
Right.
Let me, I do want to circle back to, if you all bear with it for one more question, because this is a nice forward-looking question from one of our audience members. I'd like to hear your responses. So Jay asks, when drafting new legislation, what's the balance between deregulatory and prescriptive? Lots of legislation are largely framework with standards, but don't really have enforcement. How should legislation require accountability and enforcement to be incorporated into regulations and programs created by the legislation? Especially with a lot of discussion about legislative responses to the climate crisis, with big bills being pushed forward by House Energy and Commerce most recently, and state legislation all over the country. I wonder if you all would like to respond to that from your perspectives, the role of new legislation in shaping enforcement policy.
Well, at least, and I responded online a little bit, but at least with respect to worker protections, I'm an advocate. I'm not a lobbyist. I just do that in my spare time, and as called upon to testify. Right, the brighter the line, the better. And what I have found in attempting to enforce both regulations and statutes that were enacted as a compromise, that the assumption that at least with worker protections, that if employers are given latitude and given discretion to implement protective measures, that the industry will rise up is definitely true for some element of the industry, but not true for the element of the industry that often employs the most vulnerable workers, immigrants, low-income families, et cetera. And so you need a bright line, and those compromises have generated a great deal of administrative and judicial advocacy and appellate work trying to come up with an enforceable standard. It also, those general standards also make it extremely difficult for enforcement agencies to provide effective guidelines to their enforcement officers, and for the enforcement officers to, with authority, go and say, you're violating this standard. You've got to come into compliance with X, Y, and Z. So, in general, I think the more specificity, the better. The practical reality is you're not always going to be able to get that in the context of either regulatory or legislative negotiations, and what you want to do is form a standard and legislative history that provides a court or administrative appellate division with enough direction about what the purpose and intent of that protective standard is, or that ameliorative standard is, to have it end up being protective as opposed to something that can be a truck can be driven through.
Yeah. Thank you. Joel, yeah, I know you want to get in.
Yeah, I do actually. I mean, first of all, at the federal level, I think a separate statute with regard to greenhouse gases is very much needed. The Clean Air Act and the attempts to shoehorn climate control into that it just doesn't fully work, because for one thing, it's subject to immediate change when administrations change, but also it wasn't really designed to deal with climate change. I think there are many ways that legislation can go, certainly, but writing into the statute emission controls on automobiles with a specific level that's enforceable is one thing that's needed. Also, as I mentioned before, continuous emission monitoring and auto self-reporting to a central place, no matter what the shape of the statute is, can be helpful. There's technology there that can do that. It's been used for SO2. It can be used for carbon and other greenhouse gases. No reason why that can't be done. That won't solve the whole problem. It's a complicated issue affecting many parts of the economy, but there are many things that can be done through separate legislation, and Congress has just sort of sat on its hands with regard to that. The states and some local governments are doing things that are beneficial, but that won't really take care of the whole problem, in my opinion. And so federal legislation is needed.
Thank you, Joel. And John, any last points to add to that before we close out? We've run a little bit over here, but I want to give you a chance.
I was just going to say that I echo both of their comments, because, you know, as a litigator and not a person that helps write legislation or regulations for that matter, we're stuck with the end point. And if you don't have some, as Cynthia put it, direct, bright lines, it makes it really hard to try and advocate a position either with the agency prior to litigation or afterwards before a court. And so having that specific bright line language is especially important. And I know it's a problem because a lot of people will say, well, then you're taking away the discretion of the agency. But I think what we've seen that at some points, the language is so fuzzy that there really isn't sufficient guidance even for the agency. I mean, all we have to do is look at waters of the United States and how many years we've been fighting over what the heck that means and how many different regulatory changes there have been. And you know, that's it in a nutshell.
Yeah, I think that point about delay as we sort out what the law means is really important in the context of the climate crisis. Yeah. But, you know, science is telling us we don't have time.
Yeah.
Cynthia, did you have one last thing you wanted to get in?
I just did want to give one example of when a general agency discretion has been really useful, and that is with the development of pesticides. Often legislature is not facile enough to respond to how quickly the development of pesticides are, for instance. And so again, if you have an explicit standard in your legislation that articulates what a danger is and how that's measured, et cetera, then an agency can be facile enough to come back and identify a development in technology or chemistry and address it using that standard.
Thank you for that example. That's great. As always happens, we get a few smart people who are passionate about their cause together, and conversation gets going and could go forever. So, but we've run over, and I appreciate you all spending your time with us as well as the rest of the audience. Thank you for making time for this. We'll pull up this last slide with CPR's website on it. Anybody viewing this should be able to find the recording of the webinar and our slides on the website. And with that, I just want to say thank you all and have a great day.
Okay, thank you.
Thanks.